ready to start. This is our opening panel. Hot news and updates. And we'll ask Jeremy to introduce this panel when we start. But please silence your cell phones. And like David said, if you have to answer your phone, please go outside.
All right, there we go. So, welcome to our opening panel, which is, kind of hot topics panel, and we thought that's a good place to start, because hot topics is always kind of a good overview of, sort of everything going on, a little bit of updates, and hot stuff and regional issues. So I'm DLing a little bit and also presenting. So to my left and your right, that's David Interline from Taipei, Taiwan. David, Fred Hong is from Guangzhou, China. And James Austin, if I couldn't remember his name. James is Jim. He's from Kansas City, Missouri, the Missouri side, the better side, as a former Missouri resident myself. So I want to thank them all for coming. Thanks for putting up with, what is kind of a, interesting panel, because it's kind of a, combination of a bunch of different kind of things, and they're a little disjointed. But, the first thing we want to start off with, of course, because this is a consular processing panel, right? We're dealing with consular work. I kind of wanted to go through some of, really more of the hot topics in the consular world, and, of course, the Foreign Affairs Manual. As we all know, the FAM, I will never call it the Foreign Affairs Manual besides that one time, because it's just too long. So I kind of wanted to start with that. And what I wanted to start with was walking through kind of how I've viewed the last sort of 18 months, that is, the horror show. And it's not all bad, but it's I will, there's been some changes to the FAM that I've liked, probably not related to the horror show, but I want to start. I kind of want to work through, how the executive orders and actions sort of have rippled through to consular practice, because I think they've signed all these executive actions. We've looked at them, we've gotten angry, and I think some kind of overtly trickle into the FAM. There's a lot of we're changing this because of this, especially related to BAHA, which is an acronym immigration lawyers are now using, which the consulates generally confused about, but Buy America, Hire America. That's one of them, and then some are trickling in, just a little bit more, subtly, I guess, especially around changes to vetting, related to the really long titled implementing immediate heightened screening and vetting of applications, blah, 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 for visas and other immigration benefits. So according to that executive order, I think a lot of those changes are much more subtle, going to be rolled out over a longer period of time, possibly. And it's just going to mean that everything at the consulate, never usually gets easier, but it is definitely not going to get any easier, I would think, in many areas. So I wanted to start there. I wanted to, and of course the travel ban, and I wanted to mention that just briefly as one of the other executive actions out there. As, to some extent that doesn't, I didn't want to cover it, one, because I don't think anything in our panel really deals with the travel ban too much. And two, it's not as pressing in Asia Pacific as it is in other areas, EMEA, Europe, Middle East, Africa chapter. That's definitely a concern in their neck of the woods. Less of a concern in our neck of the woods. But so we're not going to cover that one, but I definitely want to cover the vetting and BAHA. So I think the first one I really want to lead out with, related to the March 6th implementing, immediate heightened screening and vetting visas and other immigration benefits. That one is I want to talk about, public charge and affidavit of support changes in the FAM. Because I think that's one of those areas that is people have already talked about related to the FAM changes, but we all know out there since February there's been leaks that there's going to be some DHS, USCIS rulemaking, related to the affidavit of support and public charge, and there's been some leaks of some text that's out there, and that's really hard to cover at CLE because none of it's really official. There's not been a notice and comment rulemaking yet done and issued out there, so we can really comment on the text of it. But we all know in the background likely there's something going to be there, and what it is, if it's based on the text that's out there, there's a 240-something page release that I haven't waded all the way through yet, but it's really one of those areas where you can really ratchet down on public charge. So I did want to cover those FAM changes, and public charge. It's a holistic. I think the first thing we got to realize, we got to go back to the INA, because in the consular world we were kind of, especially related to immigrant visas, we were just so used to the affidavit of support somewhat being the end all be all. On IVs that needed affidavits of support, and I think that's not entirely how the text of the INA plays out. So I think fair or unfair, the FAM changes really go back to that INA and really kind of flesh it out, a bit more. In the public charge, and that's of course INA 212A4, 212A grounds of inadmissibility for public charge, and I think so. I'd like to start there, really with looking at it, because the INA clarifies like all of the factors that should be looked at when adjudicating public charge. At minimum, age, health, family status, asset, resources, and financial status, and education and skills. So that's a pretty holistic review of someone's situation. And of course has the catch-all in addition section where, they can kind of determine that any other, really relevant factors can be considered, including affidavit of support. So I think the FAM changes, which we'll get into in a second, so I can give you that site and everything else, that really goes back to the text of the INA. But where that goes from here, of course, that's the bigger question, because of course, I kind of want to go to the 1999 INS guidance that was done after IRA court, sort of, and in 64 Fed Register 28689. That was from May 1999, before my time practicing, but been around there. And that was really kind of where, this sort of, kind of totality of the circumstances, really approach was defined, and how affidavit of supports would work, and the public charge considerations, how that was really defined for how we viewed it for quite some time. And so, if there is any changes to DHS, through USCIS, to what they do with it, it may really change that sort of foundational way we look at public charge. And I really kind of want to compare, the FAM. So the FAM was, the FAM site is 302.8-2B. And in January 2018, why it's on Hot Topics, they really changed that, definition. Before, and I didn't do a PowerPoint, so I'll just read it. Before, an alien who must have an I-864 will generally not need to have extensive personal resources available unless considerations of age, health, skill, etc. suggest the likelihood of his or her becoming self-supported is marginal at best. So it really kind of, started with the affidavit of support and immigrant visas, and then worked to those other factors listed in the INA. Whereas now, the new 302.8-2B in the new FAM guidance is that in every case, I find interesting, you must consider at minimum the applicant's age, family status, assets, resources, financial status, education, and skill. These factors, and any other reasonable factor considered relevant by an officer in a specific case, will make up the totality of circumstances. So they're really going to, I know we want to get outraged by things like this because there's change and we don't like change to some extent. Creates uncertainty, but it's really going back to the text of regulations and INA. So I think that's really important to remember. And then, the last sort of thing, number 3, goes the value of the affidavit of support. A properly filed non-fraudulent IA-64 in those cases where it is required is a positive factor in the totality of circumstances. The applicant must still meet INA 212A4. So it really is kind of reversing the paradigm and the structure of the way a consular officer was adjudicating public charge. It's really going textually to where the statute is, and of course, because that change really is made, in relationship to, the presidential memo. It's probably going to lead to, some different looks at public charge, and how that all plays out. I think, it's too new to know, and it will be possibly post-specific or regional specific, how strict these things get, as it always is at consular sections. But I think, that's, a really interesting update as we look to the possibility of significant change in the affidavit support, public charge in the next year, and I know, there's going to be some opposition in that area, when, a notice and comment rulemaking is made, and I would encourage all of you to write comments, and a lot of people are going to get involved in that discussion. But I think this is one of those prelude areas, in the DOS Spring Liaison in 2018, that's AILA doc number 180413330. The State Department really says that this goes back to that presidential memo on immediate heightened screening and vetting, and reflects, a different, a more textual interpretation of the INA. So I think that's one of those changes that to me is going to be very important, especially in the IV and family. We'll see how it plays out in NIV. Just how that public charge consideration, how that looks, and probably that's very post specific and very visa type specific. We've seen more public charge determinations, but NIV, if they can 214B it for immigrant intent, they're going to do that instead of 212A4 in it. So it's in the FAM. So maybe it won't come out as much, but in the IV, I'm very interested to see where that goes. So I think the next thing, and I kind of want to continue in that memo. The next thing of interest, that I think is of interest is continuing on with, sort of revocations, admin processing delays and those sorts of things. And I think, that's been a hot topic for quite a few years now. And it continues to really be so. And I want to start with revocations, because, I remember when they dropped the DUI revocation in 2016, we were all, that's very specific. If you get arrested for a DUI, even or convicted, expect a revocation, whether that's consular revocation or it's prudential revocation by the Department of State. That's going to happen. But I think the revocations, it's going to get a bit more intense, especially in that criminal area. And as someone who I practice in Australia, in Sydney, but I practice all over Australia, for those of you who don't know, and in a country where, I guess, people are honest, and more exempt than maybe many other places, but also, spend significant time in the U.S. DUIs are a huge problem in Australia. they may get them in the United States a little bit. They may also commit some crimes in the United States. So this area becomes more interesting to me because I have a heavy E3 practice. So I have lots of people there on, who knows how long E3 stints of 2 years each. So I think, this is an area of kind of concern, and probably should be a concern for everybody, because prudential revocations, of course, our consular revocation, they're really kind of hand in by what the consular office themselves do a revocation for, right? That's only 214B, an IV visa issuance, physical removal of the visa, or the watch list promoted hits for DUI. So that's the DUI one. Those are the consular revocations, whereas prudential revocations is the department can revoke ineligibility or lack of entitlement, even if it's suspected or for virtually any other reason. So says the FAM under 9 FAM 403.11-5B. And also that's, kind of goes and, plays off, of course, the CFR, 22 CFR 41.122, where the CFR looks at revocations and that issue. I want to go back to the DOS Spring Liaison, because this is, of course, hot topic, so that just got posted a couple weeks ago. And they said in one of their answers, as a matter of long-standing policy, the department prudentially revokes a visa when it receives information that a visa holder has been arrested for any crime, including domestic violence, because the question itself related to, there's been a lot of reports of people getting arrested for domestic violence issues and then having a prudential revocation. And that may result in visa ineligibility. So my guess is, based upon that, we should be expecting prudential revocations for almost any arrest these days. And if that's, we've been seeing that a little bit, but if that's what they're going to continue to do, we really need to be careful with our U.S. clients, because, once, prudential revocation, of course, goes back to that, yeah, you can stay for the validity of your status, but once you leave, you're not going to be able to use that visa reentry, of course. I think advising clients appropriately that are arrested in the United States, because they may have an arrest and then be granted bail, be able to leave because it's something minor where they don't have really any reason they can't leave, and then what if they need to go back? What if they need to deal with those criminal charges later? And that's a concern because sometimes it can be hard to get them back in at a consular level and they need a visa. So so I think that's a very interesting area. I also think just admin processing, we continue to see a lot of it, and I think continue in this area where you can see a lot more 2.1Gs for different issues, and then also I think the other sort of delays, the admin processing after, where there's usually a DHS hit after interview. Where the consulate, you go to interview, the consulate says everything's hunky dory, and then you don't get your visa back, and then you as the attorney make an inquiry and figure out what's going on, and we're still working on it, and then you kind of can get the idea that something came up after interview, because of course it's some of the security related tasks in the visa function happen kind of after interview. So if there's a DHS hit after interview, my understanding of it is it pretty much blocks the consular from being able to issue the visa until that issue is dealt with and reviewed. And a lot of times, a properly done visa application, I've been seeing them a lot with my Australian clients with CBP issues. It's like every single one that may already been disclosed, and Sydney's been kind enough in some cases to even annotate the visa once it's issued for CBP to say, oh, that issue was looked at, which is kind of nice. Which we're supposed to do that. So I think that's an interesting area, and probably just under the extreme vetting, we're going to just continue to see more of them. The last area I really want to cover relates to Baja. As we know, Buy America, Hire America, for those of us who do significant business work, and Jimmy's going to talk about it a little bit in the H-1B context and the petition-based context, but it's really permeating kind of business practice, especially in practice like mine, where we do a lot of different types of E's, because we have 3 types of E's in Australia. E1, E2 the traditional treaty-based, visas, and we also have E3s for Australian specialized workers. I think Baja is one of those interesting areas in E's. Because when the FAM was revised after Baja, they kind of gave some guidance to consular officers I find very interesting, about how they're kind of supposed to, balance the protective, that's 9 FAM 402.9-2. They're supposed to balance those protective interests of U.S. workers, based upon Baja, because that's what Baja says is, you need to hire Americans, right? Where possible. And so it really is a balance, between that administrative priority and the idea that all these E's, they're treaty-based visas, right? Which means, they're about giving our allies and our friends, and sometimes maybe not our allies and friends anymore, but they're about giving certain countries, kind of preferential ways to open businesses and bring certain employees into the United States, whether that's, a trader, or more likely, E2 as an investor. It's about creating kind of privilege and creating good relationships. It isn't just about, adjudicating a visa class. There is kind of a broader construct to e-visas. And I think that's a really interesting dynamic when you have really kind of 2 almost opposing policy priorities in a visa category. And I think, the E's are a really special example because, of course, the L's, the P's, the O's, all of those really, you don't have that diplomacy dynamic. Whereas, in the E's, you have much broader goals. And of course, consular officers, they're not just there to adjudicate visas. They are there to be diplomatics and create relationships with that home state, even if they're, consular tracked or, in the consular section for their year. So I really find that tension interesting, and I think we don't know how that's inevitably going to play out over the long term while that executive order is enforced. But I think in the immediate term, one example I think we've already seen tangibly of how Baja is, kind of silently infiltrating the FAM. I think this one particularly, because look, I've been on liaisons recently in Sydney and in New Zealand because we've been trying to go to the Pacific part of the chapter a little bit this year, and they're all just like, what, it doesn't. We don't really look at it, but or consider it, But I really don't necessarily think that's necessarily the case. And the FAM is definitely reorganizing priorities a little bit. I think one area, of course, we've seen that is essential employees. E2, E1 essential employees. It's 9 FAM 402.9-7C. In March, April, there was, I forget which exact update the E's were in, but in March, April this year, they rewrote as the annual FAM update, right? Because the FAM just get updated kind of in a big chunk yearly and then gets trickled out now that it's electronic over the whole course of the year. But they changed, some of the essential employee stuff to really reflect what people are seeing with the employees, essential employees, that they're really going to make sure that, in the essential employees, they didn't, couldn't hire somebody else in America, right? That's some of what they may be looking at. So I think that's really, going to be interesting, because they divided up into a set, specialized skill employees, where they're looking at a variety of factors, including specifically the availability of U.S. workers with such skill. That's noted in the FAM, and the salary. And so factors where, to some extent, it's kind of like labor market testing without being labor market testing, with no perm or, LCA involved. You can't do it, of course. So, you know, and of course, ease, one of the essential components of the E, it kind of says so in the FAM, is the complete, you know, exercise of great amounts of judgment and discretion in E adjudications. So I'm really interested. That was right. I'm really interested to see, yeah, good morning, how that kind of plays out. You know, and then with the ordinary skilled workers, you know, they said almost always they're for startup or training purposes for a short period of time. So, what does that mean as we advise our e-clients when they want to bring over employees? You know, so I think, you know, it's going to be limited. And I always think this is interesting because I practice in two very different areas, right? So before I moved to Sydney, I was in Thailand, and I did quite a bit of ease. You know, I think for ease, for employees and like my chefs and things like that, when I was in Thailand, just in Thailand, Thai restaurants, like ubiquitous. It's, you got to try to convince them to do something else with an E a lot of times. It's just, you know, we always kind of saw that. They were always pretty tough on some of those essential employees, like chefs. You know, but now this is like more permeating where like places where I am now, like Australia, where, you know, your e-clients are, you know, much larger companies that are, you know, bringing a branch to the United States, and e-freeze may not be appropriate for some of their workers. So I think that's very interesting. And then, so I also note a couple more FAM changes on ease, just I thought was interesting looking at the updates. Source of funds, it's specific in 9 FAM 402.9-6B. It says, note, inheritance of the business itself does not constitute an investment, which I found very interesting. And that was one of the newer sections, I believe, because it was in italics, which is always usually means it's a new addition. And, you know, just some changes to substantial investment related to the commitment of the investor. That's 9 FAM 402.96D. You know, you may, this is new language, I think, in the FAM that I don't see as much. You may request whatever documentation is needed. This is new sort of any paperwork you want to properly assess the nature and extent of commitment to a business venture. Such evidence may include letters from chambers of commerce or statistics from trade associations, but unverified and unaudited financial statements based exclusively on information supplied by the applicant normally are insufficient to establish the nature and status of the enterprise. That's a bunch of gobbledygook. So saying, you know, certain internal company documents can't establish evidence, I think that's a little harsh. You know, but I found those two changes of some interest. So next thing we're going to do is we're going to talk about some USCIS updates real quick. So Jen, why don't you give us a recap of H's and CSPA and a few other USCIS things. Oh, God, so boring.
So we're on my update. So just a quick recap. As you all know, some of you kind of look like you've been through the H-1B wars in early April, and for all those filings. Just to get you where we are in the last, this is May 9th now, it's a month after the cap rush. All the master's cap cases, as far as we know, have been reseated, went out in the last week and a half. Now we're starting to see these are just reports we're receiving. Immigration is talking to us a lot right now. The regular cap cases, seeing checks cashed now. Nobody's getting rejections yet, as far as I know. We're seeing regular cap cases, checks cashed, some receipts have gone out. And this week, I think they reported someone's seen the first RFE for a cap case. So it's nice to know that they're fast with the RFEs. You don't have the receipts yet, we got the RFEs. Just one that I've heard of, and it's been reported. That was, you don't want to make a guess on what's going to happen based on one RFE, but once again, apparently it was for a level 1 wage, saying it's not a specialty occupation. So we shouldn't project that into saying that this is going to be just like last year, but it certainly is an unpleasant start. So that's where we are with the H-1B right now with cash. Cover anything else? You want to stop there?
Yeah, let's do CSBA. You have some interesting
got a couple. A couple little quick tips on Child Status Protection Act. This is always difficult to discuss. Anytime you start talking dates for filing and final action dates and sought to acquire a CPA, it always turns into a grammatical nightmare. And so trying to properly explain it, there's been a couple issues with CSBA. You have to, for the derivative documents, you have to show that you have sought to acquire within 1 year of visa availability. That's what the statute says. So the issue is really going to be, what about these cases that we are doing sought to acquire prior to visa availability? Statute is a little funny. Statute will reference the after visa availability. And there's never been a direct answer to that. And this is becoming even more important now as we're seeing the National Visa Center occasionally starting the documentation process more than a year before visa availability. So, will something that you sought to acquire a year and a half before visa availability count as sought to acquire within 1 year of visa availability? It gets stranger. The National Visa Center in Liaison did answer this question positively that says, yes, these actions taken prior to visa availability, they do consider that as sought to acquire under the Act. And from what we see, almost in the way that it's been working with National Visa Center and also through National Benefits Center, who does the stateside adjustment and these issues. It's almost as if the government is taking sought to acquire within 1 year after or any time before. So it's been very generous in the way that we're seeing these cases looked at, even though it's not official except the National Visa Center one time. So that's an interesting thing on sought to acquire. So that's a positive thing because it was more restrictive. Remember when it first came out in the FAM, there were only 3 ways to sought to acquire. Now it's slowly expanding, so it's getting better. The other issue with CSVA and sought to acquire is for stateside practitioners doing adjustment of statuses. For family-based cases, you have the bifurcated visa bulletin. You have the file by date, or dates for filing date, and the final action date charts. And you will see people that are derivatives that are assuming that they're going to be CSPA age saved by filing their application before the dates for filing, or I'm sorry, before final action date is current. And this is, we're doing this with a lot of adjustment cases. You're filing using dates for filing, but you do not do the CSPA age calculation until a priority date is current. So those people who are filing adjustments for derivatives before the priority date is current, they're filing using that dates for filing. If they're not CSPA protected by the time their priority date becomes current, then they, in most cases, have wasted their money because they are not protected by CSPA. They're just guessing that when the priority date later becomes current, that their CSPA age is going to be under 21. Sometimes it's not, and that's creating some problems with people filing with the National Benefits Center and the case later being denied because they're not protected. The lucky ones in those cases are people that are filing early, that are filing as a direct beneficiary and family-based second preference fee, the child of a permanent resident, or 2A, the child of a permanent resident. If they filed early and then when the filing date becomes current, they found out that they had aged out, they were no longer CSPA protected. So far, the National Benefits Center is holding that case, and they've been holding this case for many years. They're treating that as if the old retrogression rules. They filed properly when they were allowed to file, but then the category and the priority date changed. And so they're holding that. So for many years, those cases will still keep getting work cards until that priority date in the 2B category becomes current.
Yeah, Jim, do you want to talk about, secure document delivery real quick? Just for fun.
Yeah, but
it's a good idea. It's a good because it affects both people in the States and the consular practice because after your ID interview, you want your green card in the mail. So
yeah, this is a good heads up. Those of you who know, the government announced a new policy a few weeks ago, a week ago, that they're going to start using secure document delivery, which requires special signatures. It's a special program of the Postal Service. There was a teleconference on it on the 3rd. I didn't get to do it because I was traveling. There are a lot of questions raised by this. This requires that the person directly, that is The person named on the document on the address has to sign and show ID to receive that secure document. This is mainly going to be for green cards and work cards. But this is another program by immigration where they never considered how this affects attorneys. I mean, for individuals, it's going to be bad enough. But for attorneys, how do we do that? It's direct to our address and the client's name. There's no one there to sign for it. And these are going to be a problem. And in some places, I know in our office, my friend does a lot of view adjustments. And we will, and not just you, but we'll get, for a small office, we'll get 6 to 12 work cards or green cards a week. And sometimes they're addressed to us, sometimes to the individual client. And all the views go to the attorneys. So all those documents come to us. We do not ask for documents to be sent to us. In normal case, we want to send to the client. We want to be out of there. How are we going to sign for that? There is a form that they said that you can sign, the applicant can sign to designate a person. But this is tricky because the applicant has to ID to do that. It's a one-time thing. It has to be submitted to the post office to authorize someone else to get it. It's really going to be quite a nightmare. We don't know where this is going to end up. It just started May 29th, and they're starting the program just on documents that have been returned as undeliverable. So this week, probably, I don't know, what is the stateside, Tuesday or Wednesday, we'll see, the attorney's just going to see the first ones of those delivered to them for documents that were returned for us. And then we don't know when they're going to start with all green cards and work cards, but hopefully there'll be some more information, so just kind of stay tuned and see how we're going to be able to get these documents.
Yeah, and thank you. And the last sort of USCIS update, and I'll cover this one, is just the new policy memo on sibling cases on DNA. So I think this is good news, really. You know, and I was talking to some of you today and yesterday about it, but you know, I don't do a lot of cases anymore that require DNA testing. But you know, I think this is good news because it kind of opens up the sibling relationship for DNA testing, and you know, 90% probability, you know, based upon that testing. And I'm not a science person, so I got whatever they do with DNA testing to match it all up. But if it's 90% or better match, then you know, that's, you know, going to be really, really good evidence that those people are siblings. So you know, if it's between like 9 and 90%, it's some evidence, it's probative of some sort or not. And if it's less than 90%, well, that's probably bad news. So that policy memo is PM 602-0106 and called DNA Evidence of Sibling Relationships. So that came out as a policy memo, I think 5 days ago. So I think for those of you who do preference family cases and do some F4s, you know, that's going to be really helpful, especially in this area of the world where, you know, this is one of those areas where I think, you know, that is going to, you know, be a helpful situation where, you know, now DNA testing might be the evidence you need to help your siblings finally get reunited after a bazillion years, you know, not living in the same country, especially if they're in certain countries. Yeah, and it's a step sibling stuff. So I think, you know, and it said, you know, specifically in the kind of news alert that USCIS policy on parent testing remains unchanged. So that's based upon you know, that prior guidance in that area. You know, so I think, you know, I saw that pop up, and if everybody isn't registered for USCIS updates, please do. You get the nice daily updates from USCIS about everything they're releasing. You know, it's really quite helpful. So that came up a few days ago, and I wanted to add it to this panel as I was kind of putting it together. So at this point, we're going to turn it over to David. David's going to give us a little updates on some, you know, EB, you know, employment-based and EB5 related.
Thank you, Jeremy. I'm going to use some slides so you don't have to listen to me. Yeah, I'm going to come off. I'm not going to talk. I'm just going to. You can all interpret it. No, I'm going to talk about some hot topics in the region in the EV categories.
So if I can find my slides. Okay, I'm going to start with EB1 category. Those of you that practice. No, I got to get the PowerPoint up. Well, I need to get this full screen. All right, I'll go ahead and scroll. So just something I want to point out, if you practice in the EB categories and have the Chinese clients, then you probably would recognize this. Those that don't may not have noticed. This is a chart that shows the past 3 fiscal years. The EB1 category for China and India goes current. It started going current in 2016. Usually by the end of the fiscal year, there'd be a priority date listed. And in 2016, it started in August, September. But then if you look at 2017, so then you look at 2017, they set a priority date in June. And in 2018, it's in April. So this is indicating higher and higher demand, specifically, I believe, out of China for the EB1 category. So as you can predict for the next fiscal year, it's probably going to be set even earlier. My guess is much earlier, maybe in December or November, because we're seeing increased demand in the other categories because of the EB5 situation for Chinese petitioners. So as everybody should know, there's a per country cap. Of course, every country is going to get their percentage, but that's not really that many per country. So if you're involved in assisting Chinese investors in the EB1 categories, you can expect these just to have longer and longer delays going forward. Next thing I want to talk about is I want to share some information about the EB3 situation. All right. You may or may not have realized that about 4 years ago, the EB3 categories, specifically unskilled workers, went basically, practically it's current for most of the rest of the world, not the main countries that have their own listings, China, Mexico, Philippines, India, etc. So what happened about 3 or 4 years ago is some entrepreneurs realized that there's an opportunity here. They went to some of the countries in the region that have a well-established immigration consultant and agent network and put together opportunities for people to apply as unskilled workers and introduce them to employers in the U.S. that were having difficulty finding workers and qualifying for labor service. So what happened was, and I recognized this in Taiwan about 3 years ago, for about $70,000 US, I could go to one of these consultants and pay and get a placement opportunity with an employer in the US. 2 years ago, there was an ad in the Hong Kong newspaper, $120,000 to get a green card. $120,000 US. And all I have to do is go to the US and work in a Pizza Hut in Texas or a chicken processing plant in South Dakota. And the obligation would be 1 year of employment. Whether they actually show up and are employed after they get their green card, we don't know. I've heard some of these agents suggest that they don't actually have to show up. So what happened was, especially at AIT, is they stopped issuing the visas for a while under administrative processing. Recently, we've heard that I heard there was one agent that placed 600 workers out of Vietnam. But we also heard that Ho Chi Minh stopped issuing those visas for administrative processing. It's been going on for about a year and a half. And so we're guessing that it's based on this section here, which 20 CFR 656.1. Applications for permanent labor certification and approved labor certification are not articles of commerce. They shall not be offered for sale, barter, or purchase by individuals or entities. Any evidence that an application for permanent labor certification or approved labor certification is sold, bartered, or purchased shall be grounds for investigation and may be grounds for denial. Now, this is conjecture. We haven't really heard anything conclusive from any of the consulates that are involved. Perhaps maybe some today might share some insight into this, but I have heard that more recently they started issuing the visas out of AIT, but I haven't heard about Ho Chi Minh City and any other consulates around the region. It's just something really interesting that the employer obviously is not allowed to require the employee to pay, but there are middlemen involved in here. And so that's why I think they're trying to get around that in some way. So just an update on what's going on in EB3 soon. The last is just a quick look at visa numbers under the EB5 category. We're not going to go into much detail. I just want to post these so you can see the trend. Most people probably realize that China has been by far 85 to 80% of visas in the EB5 category. If you're Chinese now, Chinese born and you apply, you file a petition today, it will take you 15 years for your visa to become available. 15 years. And we'll talk about this more in the EB5 panel later today. High increased demand in Vietnam. They're now number 2 in visa issuance. And then South Korea, Taiwan have always have remained very steady. India has been a lot of growth. So you can look at the last fiscal year 2015, 16, and 17 and see where the growth is. Hong Kong, reasonable. The rest of the Southeast Asia, really, there's not been a lot of demand. That's all I have.
Thank you, Dave. So next, and now for something completely different. What we're going to talk a little bit about, the post, kind of where we are. So I want to introduce Fred. Fred, a long time practitioner in this area of the world. So he's going to kind of give us an update on some, mission China processing. So Fred.
Thank you, Jeremy, and thank David and Jared for inviting me to this panel. Topic is hot topics and hot news. So I guess for China and US, 2018 started with very challenging times, starting with the quote-unquote trade war that we all heard about. But so-called trade war is still unfolding, but it's not just tariffs. We're talking about tariffs on both sides, but actually there has been whole area on so-called technology, transfer technology, stealing technology in the U.S. field. First, China, only try to force or pressure the U.S. companies in China to transfer technology, and secondly, we've heard about maybe students from China going into the U.S. in science, engineering, maybe, there's some also public hearing and mentioning it can be spies, students from China, spies. So this whole technology area is important, and I would have a few areas right now. Technology, how does the trade war, technology transfer imply to visas from China to the US? Secondly, will be in that sense from technology side to the students visas this year or next year. What does it mean to the STEM people or whatnot? And thirdly, maybe a little bit EB5 Ls, EB1As, the fraud prevention area in China, and just a couple points. And then last, maybe the access, so-called, in China to the 5 consulate, especially Guangzhou. On the technology side and TAL, and all that, I think, well, the latest, few weeks ago, U.S. Commerce Department prevented or stopped the selling of all chips and related accessories to ZTE company in Shenzhen. So that we understand, and that hurts because it's regarding chips. Now, all this, what does it mean? In general, it's not too interested, but at least I want to point out one concrete case which I came into contact in April, this last month in Beijing, which will maybe, as example of what does it mean by technology and getting into the visa area. This person is 30-ish lady, Beijing, and graduated in college, master, bachelor, and then she has the first, this is talking about B1, B2, very simple. Now, but it may spill into H, and L's and O's, and EB1, A's later on. She has gotten her B1, B2 in 2007, first visa. No problem. And then since 2011, she's been getting her visa B1, B2 every year. So she has a good job, mother of a 5-year-old kid, married in Beijing. 2011 onward, she only got the B1, B2 once, every year. 1 year, not 10 years later on, because she had to go through clearance. So, but it's okay. From 2011 to 2017, she's been getting her clearance, B1, B2.
For SAO, yes.
Yeah, and mainly where she worked in technology area. But in January 2018, this year, annual clearance, which was not, administrative processing, 5 days, 2 weeks, she got denied clearance. So she went back, she didn't know, there's no 214B issue. So we went back in March, Beijing, and just say, no, go away. Not too much question asked. So she asked for help in April. I went through the whole thing. And what I think happened, and you have to look at the bio, okay, she happened after graduation in China. We would say she worked for the right companies. She's in IT and communication. She worked for ZTE before. She worked for Huawei, and then the last 8 years she worked for Legend Group, Legend Computer. Now these are good companies in China, good pay and high tech. But I think for the US, she just got into the wrong company when it comes to TAL technology. Now, the last 2012 to now 6 years, the current employment for the last 6 years, Legend Group, Legend Computer, or IBM. So I don't think, I'm not too sure, Legend is one of the restricted TAL company. But after she graduated, she worked for Huawei for 1 year. Now Huawei, I heard, after CTE company is being investigated by the US on possible, technology selling to Iran and whatnot. But she worked for CTE, which was a foreign company as far as the TAL was concerned, I guess, 2008 to 2012. So she worked there 4 years, 6 years ago. So, but all these years after she quit ZDE and then Legend, she's been getting clearance every year, B1, B2. But January, she got denied. March, denied. Her own situation is the same, working for Legend. But I guess the TAL technology, alert list and whatnot has been changed. So it's nothing to do with the embassy, but definitely security area to work for the wrong company. Now, she is one of those people, I think in China, that might be involved in this area. I told her I couldn't do anything. Maybe 6 months later, she goes back to B1B2 to see if any clearance you can get. Maybe not. But what happened to H1Bs, people, Ls, E1, EB1As, Os, who may be in this area, who had worked for Huawei or ZTE 10 years ago, would all these people, spill over and get denied? Not just Bs, but Fs. So that's one thing I feel need to be looked at, but definitely this case says something about the visa process in China. Secondly, will be the students. We heard about STEM, science, technology, engineering. Now, I have not done specific case to report, but what I worry about is not new students. I know Chinese student and student overall, the U.S. foreign student has dropped, and I think Chinese student will drop too. I heard some parents decided not to send their kids to high school and all that in the U.S. But I worry about returning students at MIT and who knows, Berkeley, in engineering and IT. If they have to come back, okay, if they have a 5-year student visa is fine. If they go back to anyone at the consulate or renewing, if they are in STEM and all that. Now, of course, the visa officers later on this afternoon, they say if there's anything from Washington, they give them. But what I feel is, consular processing, individual student visa officers have their own thinking and meaning. If some officer felt they heed the call, so-called from Washington, D.C., feeling these people may not be to the interest of the U.S. to go to schools there and have refused. So I worry about if renewing students, people coming back and go back there in the middle of their, college studies and get, administrative processing and delay or refusal or scrutinized. That would be a problem for us. And last, one quick question I want to, on EB5 and else, I'm talking about fraud prevention. Okay, China and specifically would be site visits. What I heard a couple months ago, even EB5, usually EB5 there's no site visits. There were site visits in 2 companies in Wuhan. Has to be IV, has to be from Guangzhou. They visited 2 EB5 companies, applicants, and asked for the company balance sheet, income statement, and then I guess one company show the company or individual assets and balance sheet, income statement, which is not the same as what was filed with the 526. Okay, so that problem created. Now, I've been in China long enough. I've not heard about EB5 site visits before. So things are happening, and L's, of course, right now, EB5 15 years. A lot of people go to L's and EB1As, EB1C, which site visit I've heard a lot more from the FPU, the fraud prevention unit. So that we have to watch out and see what happens.
Yeah, Frank, you got like 1 minute. So why do you address communicating the consulate with challenging?
Lately, I feel mainly if it's communication and IVs is very important. China, which is Guangzhou. NIVs is all over the place. 5 consulate. What I feel has been maybe the consulate section chief, maybe Guangzhou has been efficient. They do respond, and some of the time it's not just the local employee, but I can see the responses written by vice consul. But one area I want to alert people is you always get the G28 issue, okay? Even if you're a attorney of record or you're a new attorney, consular processing, maybe whatever file before was attorney of record, but we are not. But they always come and say, you're not G28, no answer, no nothing. Now, one advice I said, you have to keep submitting 1, 2, 3 times because they like to say, I don't need to answer to you. It takes a while, but do not take them, no G28 and then block and get frustrated. You just keep going, keep saying it because eventually they get it. So that I would say
that's a good tip from almost any post that's hard to communicate with.
And I find this very interesting. Most of the Southeast Asian hosts that we talk to, they're very open about recognizing the attorney if there's a letter on letterhead or even the signature in your email. They'll accept that you're representing. But Guangzhou,
They
ask Ben later.
Yeah. Thank you, Fred. So I think we're about out of time. So yeah. So I don't think we question. Do we have time for questions?
You do want to a question, yeah.
Like a couple questions. Sure.
Yeah, the DOI record, Jeremy, that I have a client with the DOI not convicted, but DOS canceled the visa without an email. But I'm asking, how does the DOS communicate with the police fingerprint record? How do they know? And what about domestic violence? Do you think that the person with
The security states.
Come
Come on, and I would say the U.S. government for a long time was really far behind, probably on computer records that mesh together and everybody could access them. But nowadays it's just better and better. I would assume it gets better every month for that. CBP seems to have more access to fingerprints. At their fingertips, DOS has more access to fingertips. The FBI checks are pretty good for the most part now since the early 2000s, right? So that's how.
Thank you, guys. If you have any questions, we can do it offline. We have a short 10 to 15 minute break, then we have next panel. Thank you.